Hello, everyone. I want to welcome you all to our second lecture of Women on the Margin, about women on different margins in Israel. This event is brought to you by the YNS Nazarian Center for Israel Study in co-sponsorship with the UCLA Center for Near Eastern Studies. And we are going to host today Professor Rauya Aburabia, who is going to talk about her lecture titled Excluded from the Law, Muslim Women in Religious Courts in Israel. I would like to welcome everybody who has joined us from all over the globe, including Poland, Turkey, Jordan. We have people from Anguilla, Brazil, Ireland, Canada, Israel, and all over the US. So I'd like to welcome you all. And I would now like to introduce Professor Rauya Aburabia, who is a phenomenal scholar and a very good friend. Rauya Aburabia is an assistant professor of law at the Sapir College School of Law and a visiting scholar at Aix-Marseille University and the Institute for Research and Studies on the Arab and Muslim World. She earned her PhD from the Faculty of Law of the Hebrew University in a joint program between the Hebrew University and Free University of Berlin, Human Rights Under Pressure, Ethics, Law, and Politics. Professor Aburabia received her LLM in International Human Rights Law from the American University. She teaches and researches in the fields of family law, international human rights law, feminist jurisprudence, and minority rights. Professor Aburabia has received several awards for her academic and feminist work. She was awarded the Ma'of Scholarship of the Council of Higher Education for Outstanding Arab Scholars, as well as she was selected by Globes magazine as 40 under 40 for most promising young leaders in Israel in 2018, and by 972 magazine as Person of the Year, Women Activists of the Arab World. Professor Aburabia practiced as a human rights attorney for the Association for Civil Rights in Israel and has been at the forefront of several civil rights initiatives concerning the unrecognized Bedouin villages and Bedouin women rights in Israel. And today she will explain to us and share her research on polygamy and on the plight of Muslim women in religious courts in Israel. Please join me in welcoming Professor Aburabia.
Good morning, and thank you, Tamar, for this generous introduction, and thank you all for joining us and for this invitation. I'm really delighted to be here this morning and sharing with you some of my research. So I'm going to talk about the entrapment of Bedouin women in polygamous marriage and the way they are actually entrapped between national boundaries and patriarchal structure. But first, I would like to start and talk a little bit about polygamy, and so we will understand, have a little bit of background regarding this phenomenon. So basically, polygamy is generally practiced in 950 societies across the world. Polygamous marriages exist in the Middle East, North Africa, Eastern Asia, and in some communities in Europe and North America. Many estimates indicate that polygamy is about 20% of the Bedouin households, which the Bedouin are part of the Palestinian minority citizens of Israel. Moreover, in the past 3 decades, there has been a consistent increase in the number of polygamous marriages in the Palestinian Bedouin society in Israel. Polygamy is increasing irrespective of age, education, or socioeconomic status. Under international law, polygamy is perceived as discriminatory, and it's associated with all forms of harms to women, physical, mental, sexual, reproductive, and economic. Under the Israeli law, according to the punitive code, polygamy is a criminal offense. However, under the Shari'a law, which is the Islamic law that governs family laws for Muslims in Israel, polygamy is permitted. As a consequence, due to the fact that the state of Israel doesn't enforce the criminal code, which prohibits multiple marriages on the Bedouin citizens, polygamous marriages is religiously valid and practiced. This situation creates ambivalence and contradiction, and this ambivalence of the Israeli legislator and the legal system violates the human rights of Bedouin women and creates a situation in which they are basically excluded from the law by the different legal system, by the criminal law, the Islamic law, and customary law that also exist and practiced by the Bedouin community, which is part of tribal community, minority within a minority. It raises significant questions about Bedouin women's citizenship and human rights, and about the role of family law in the Jewish state in Israel, a state that segregates Bedouin society by supporting the traditional tribal system and by condoning practices such as polygamy. The analysis of these issues, which illustrate the strength of the fortress nation at the global era, constitute the main axis of my talk. I will focus on family law in the Jewish state as part of the Israeli nation building project, with special focus on family law and Bedouin women. I will try in my talk to address the ambivalence of the Israeli legislator that applied the prohibition against bigamy on Muslims in 1951, but didn't enforce it in the case of the Bedouin community, where it is mostly common and practiced in comparison to the general Muslim community in Israel. I will try to offer three possible explanations for the ambivalence of the Israeli legislator. I will see how much time I will have to delve into all of the explanation, but I will state them. The first explanation that I'm offering is the limited application of the Women's Equals Rights Law of 51 in the case of the Muslim women. The second explanation that I will evolve is Israeli lack of enforcement policy toward polygamy. And third explanation that I'm offering is the construction or the placing of polygamy in the private sphere and the tension between the public and the private sphere in this case. I will conclude that these phenomena encourage the practice of polygamy and exclude Bedouin women from the law, denying them any legal protection in case their husbands decide to marry another woman. So let's start by brief, short theoretical inputs that will help us to understand what we're actually talking about. So in Israel, there is no clear separation of religion and state. Religion in general, and the Jewish religion in particular, enjoy a formal constitutional status in several areas, most significantly in the domination of religious law and family law. Personal status matters are governed by religious communities' laws and courts descended from the millet system of the Ottoman Empire. Family law has an important role in nation-building projects, both in creating communities and in defining their borders. The Israeli legislature adopted the British mandatory family law due to its benefits for the Israeli nation-building project, in which egalitarian modern family laws were rejected in favor of religious communitarian boundaries. As a result, as the majority in Israel, Jews and Jewish institutions dominate Israel's political sphere. The dominant position of the Jewish religion in Israel bolsters Orthodox authorities who become the gatekeepers of fortress nation. So the formal standing given to religion and religious law in Israel has a vast effect on the Arab Palestinian minority in general and on Bedouin women in particular. Palestinian citizens in Israel are marginalized and discriminated against by the state on the basis of both their national identity and their religious affiliation as non-Jews. They have been subjected to control policies since the establishment of the State of Israel. Bedouin women even face multiple forms of discrimination as a minority within a minority on the basis of both their national belonging and their sub-membership in distinct tribal groups. In addition to social and political discrimination faced by all Bedouins, Bedouin women suffer from further subjugation due to the marital structure of the Bedouin society, in which there is a preference for marriages between cousins, a practice meant to curtail marriages to members outside the family and the tribe. Furthermore, Bedouin women are excluded from all decision-making processes concerning their own family or personal status. The social value of marriage, in conjunction with the social legitimacy of polygamy among the Bedouin society, forced Bedouin women to become part of polygamous marriages. The lower status and social and economic status of Bedouin women increases their dependency on their spouses and affect negatively their ability to resist polygamous marriages. In addition, Israel doesn't have a system of civil marriages and divorce that would allow members of community to evade the marriage authorities of the religious groups. Therefore, the right to exit is limited. Bedouin women's right to exit is further curtailed by the informal internal tribal intrigues to which they are subjected. The lack of separation between religion and state and the exclusive jurisdiction of Shari'a Islamic courts on marriage and divorce matters for Muslim citizens of Israel have an adverse effect on Bedouin women's citizenship and impose restrictions on their legal freedom. It illustrates the confluence of interest which stand at the root of their subordination between the preservation of oppressive patriarchal norms and Israeli control policies. This situation is further exacerbated by the marginal legal status of Bedouin women in Israel, and in particular by their exclusion from the Women Equals Rights Clause, which was never intended to provide them with legal protections. So I will now talk briefly about the first explanation that I'm offering to this gap between the criminal offense of bigamy and the lack of enforcement. So the first explanation that I'm offering is the limited application of the Women's Equals Rights Law that was enacted in 1951. This law was proposed in Section 8 to apply the prohibition against bigamy upon all religious communities in Israel. In fact, this law canceled already in 1951 the exemption for Muslims from the criminal offense of bigamy that was in effect during the British Mandate period. In the framework of the discussion regarding the citizenship of women, no mention is made of the Palestinian women in the Women's Equals Rights Law. The citizenship of Jewish women is presented primarily by their contribution to the states as mother. One can deduct then what this means in regard to the citizenship of the Palestinian women in Israel and their marginality in this context. In fact, their citizenship was hollowed out from the start, emptied from all independent political or legal content. Israeli law was never designed to protect them, as the Women's Equals Rights from 1951 that enacted and was said that the criminal offense against bigamy will apply to all religious groups, but in fact it was never enforced in the case of the Bedouin community. Let us just remember historically that the 50s was the first decade of the state of Israel and the formative decade for state law. It was about building the Jewish nation, and therefore it was important that monogamy will prevail among the Jews as part of their enrooting and absorption in the Israeli society. Therefore, in the new Zionist state, bigamy was destined to disappear. Muslims were included in the law, but I argue that it was only declarative and it only derivative from the official commitment to equality of all before the law, and there was no actual intention of enforcing it, as the statistic demonstrate, as I mentioned, that 20% of the Bedouin household today are polygamous. So this is the first explanation that I'm offering briefly. The second explanation that I want to offer for this gap is related to the way that enforcement authorities perceive polygamy. So since we're talking about criminal prohibition, one of the most important issues dealing with the criminal prohibition against bigamy is the question of enforcement, and in particular, the effect of the lack of enforcement policy on the legal status and citizenship of the Bedouin women. So, according to the guidelines of State Attorney's Office concerning the enforcement of the prohibition against bigamy, in order to file charges against suspect of polygamous marriage, the state must have evidence of a legally binding marriage ceremony. Enforcement authority assert that the informal performance of polygamous marriage generate evidentiary difficulties in proving it. From what I found in my research, when I looked at the cases that brought before Shari'a court in Beersheba, I saw that there are evidence and declaration of the parties that one of the party was polygamist. So I saw that when they come to the Shari'a court to ratify their marriage, they already, you can see from the cases brought before the court that such an evidence is already provided. However, state authority, especially police in this case, from what I found in my research, intolerance toward such a phenomenon. Some enforcement authority perceive polygamy as an intrinsic part of Bedouin customs, cultural norm, and as such, there is no need to fight it. Others attribute the lack of enforcement to Bedouin women, who they claim are not filing complaints against their polygamous husbands. But in fact, from the data that I checked and analyzed, the data demonstrate that even when complaints were filed, and they were filed, very little significance was accorded to them by the state enforcement authority. The data suggests that almost half of the cases were terminated due to what was deemed by the authority as lack of public interest, and only 20% of cases are eventually brought to the state's attorney office or prosecution to decide whether to press charges. Police records regarding polygamy, for example, from the years 2016, illustrate that 86 cases were opened following complaints alleging bigamy, when 21 such cases opened in 2015 and 65 in 2016. But in matters concerning enforcement policy, inquiries regarding the following subject were posed. For instance, the range of sentencing in bigamy offenses, the reasons for closure of so many cases, and the specific justification for these closures, whether these justifications are relied to the complainant in each case, whether in any explicit or explicit overreaching policy regarding the non-enforcement of cases of bigamy, and whether an underlying explanation could be found for these non-enforcement policy against bigamy offenders. The de facto policy of police non-enforcement, together with the routine ratification of polygamous marriage by the Shari'a courts, led to a legal reality in which Bedouin women are underrepresented and unprotected to the degree of being legally transparent. The fact that almost half of the complaints between 2010 to 2014 are discontinued due to lack of public interest, and charge of criminal activity are seldom proceed, illustrate the lack of interest on behalf of the authorities toward Bedouin women and their legal rights. Israel's lack of enforcement policy reflects the degree of state intervention in the private sphere and its significant role in the delineation of the boundaries of Bedouin women citizenship. Which brings me to the third explanation that I'm offering to this gap between the the criminal prohibition against bigamy and the lack of enforcement. And I will just emphasize again that according to the religious law that is valid according to the Muslim community, polygamous marriage are valid according to Sharia law, that is a criminal offense. So now I want to delve more and talk about the third explanation that I'm offering to this gap, which talking about the location or the positioning of polygamy between the public and the private. So as we know, traditionally civil society has been divided into the public and the private spheres, with women and family occupying exclusively the private sphere. The control and subjugation of women are fundamental to the social order. We know from the scholarly writings that a sizable portion of the cultural inhibition that women face, and then the inequality of women, stem from and flourishes in the privacy of the household. Cultural practices that involve the oppression of women can be hidden in the private and constructed as familial matters. Thus, the distinction between the private and the public therefore play a central role in the delineation of the boundaries of citizenship. The distinction determines the degree to which the state does or doesn't allow itself to intervene in the private sphere. And it's very much linked to our discussion about polygamy that is positioned actually in the private sphere as part of the marriage and divorce law, in which the state doesn't intervene and under the exclusive jurisdiction of religious courts. And it curbs the civil liberties and rights of Bedouin women in a manner that arguably nullify their citizenship altogether. The construction of the boundaries between the private and the public is a political act. The state set the boundaries for intervention, passively or actively, even when it decides not to intervene in a certain practice. So in placing bigamy and polygamy within the private sphere, as part of the marriage and divorce laws that are under the exclusive jurisdiction of religious court, the state effectively preserve and bolster the supremacy of patriarchal norm, particularly in light of the crucial social role played by the dual institutions of the family and marriage, where women are vulnerable to exploitation and economic and social abuse. In preserving reproduction, traditional national role for women as bearers of children and dependents of their male counterparts. By not intervening in the practice of polygamy, which oppresses women, the state preserved the institution of marriage as patriarchal institution, and in doing so, exaggerated the harm done to Bedouin women. The matter is further exaggerated by the inferior civil status of these women as Palestinian in a Jewish state, not only relative to the status of men, but also due to their belonging to an ethnic minority that is excluded and discriminated against and as part of the tribal society. So in fact, this placing of polygamy in the private sphere actually harm Bedouin women status, legal status, and affect their other positions within society. So to conclude, the ambivalence of the legislator and the enforcement authorities demonstrate how the lack of enforcement policy encourages the practice of polygamy and excludes Bedouin women from the law. By bolstering the patriarchal control of Bedouin women by the Sharia court and by the traditional customs. And in this, I want to stress that also the polygamy that actually is valid and practiced according to the Sharia law is actually taking place outside of the realm of Sharia court in a traditional matter. And then after a period, between few months, and it could also take few years, come to the ratification of the court. So it's a totally a contradiction between several legal systems that is taking place at the same time. As I mentioned, the criminal, the customary law, and the Sharia law. And one of the results of this contradiction of this legal situation is actually the absence of legal protection according to Bedouin women. These women are bereft of any legal defense in case their husbands decide to marry another woman, living in a situation in which they are virtually transparent, invisible in the eyes of the various legal systems. The criminal prohibition is not enforced among the Bedouins. Second marriage are valid according to Sharia law, and the customary legal system is legitimizing polygamous marriage. The lack of this legal protection is confounded considering the discrimination of the Palestinian minority in Israel faces and ultimately has further effect on the subjugated political and civil status of Bedouin women, eventually curtailing their ability to eject themselves from their societies and to extricate themselves from its oppressive patriarchal practice. The ambivalence of the Israeli legislature reveals the underlying patriarchal and national assumptions with regard to family, women, and citizenship. The positioning of polygamy as part of the private sphere that is outside of the limit of the state intervention segregates Bedouin society by encouraging the practice and exclude women from the protection of the law, negatively affecting their human rights. It demonstrates the role of family law in the Jewish Zionist state that applied the criminal prohibition against bigamy on Muslims already in 1951, but exempted in practice de facto the latter based on their ethnicity. Last, the Israel example of polygamy has important implications for understanding contemporary minority politics in Israel and introduce us with a new conceptual framework for understanding personal status law of Palestinian Bedouin women in Israel as a political paradigm. Thank you.
Thank you so much, Rawia, for this really fascinating talk. I encourage everyone that is interested to please submit your questions in the Q&A box of the chat. And I will start by asking a few questions. I was wondering if you could perhaps explicate why is polygamous marriage such a negative outcome for Bedouin women? What are the human costs and social costs of polygamous marriage to the Bedouin community and to the state of Israel in general? Thank you.
Thank you, Tamar. So first of all, polygamy has been recognized as a harmful, oppressive practice according to international human rights law from so many aspects, but also it's trap women in patriarchal structure, with leaving them with no legal protection, giving the legal and social status of Bedouin women being part of a minority. They're a minority within a minority. They're not just discriminated against as part of an ethnic national minority, but they're also a tribal minority, which means that their subjugation even harsher. Their opportunities to exit this structure are limited in the first place. There are amount of scholarly literature relating to the psychological effect on women and children in polygamous marriage, the high percentage of depression, anxiety. There is a recent research that talk about depression after birth, and it analyzed this situation among women in polygamous marriage, and it shows that the depression after birth is even higher among polygamous women than women that are not in polygamous structures. So it's harmful in so many aspects, but also eventually, I think when we want to see what happened in society and want to have a sociological analysis, we need to see how the situation of women is look like. And this is like a particular thing, but if we zoom out also, the fact that there is no separation of state and religion in Israel, the fact that women in Israel, whether they're Muslims or Jews or Christian or Druze, are still subjected in marriage and divorce matters to the exclusive jurisdiction of religious courts. They are, I mean, I don't have enough word to express this, and I'm teaching family law, and the students always surprised when we're talking about this issue, that this is, of course, harm women in particular, especially in such complicated, diverse context.
As we know, actually, the Muslim courts have been recently have a female qadi, a female judge has been appointed, which is much more progressive than is what is happening in the Jewish religious courts. And could you tell us if you think that is an avenue for changing these dynamics, for changing the patriarchal control that is currently dominant in the religious courts, and in particular, of course, in the Jewish and Muslim courts?
Yeah, of course, when the female Muslim Qadi was appointed, all of us, like scholars and feminist activists, were celebrating this accomplishment. And of course, it was also due to intensive activism of feminist movement, the working group for equality on personal status matters in Israel, that I also was part of. But the fact that it was it happened because according to Sharia law, there is no problem that to appoint a female judge or female qadi. It already happened before. It happening in the Muslim and Arab world, in the West Bank, there already were female qadis, so there was no limitation, no legal limitation according to Sharia law, so it was easy to happen. Now, if you take the rabbinical court, since the Orthodox is the dominant, the dominant thing, it will not happen. If it was a reform, it was something else. So actually, this is also, I mean, it was a big hope for the Muslims or for feminists, but I cannot see how it will happen in rabbinical court in its current constellation. But still, we have to see whether the cases or the decisions of the female qadi are differ from the male qadis, okay? Because eventually they're all taking decision according, like the framework is the religious law. So I don't know how much space or options or sphere they have to maneuver it. But still, I think it's an important case, not just symbolically, also that could tell us more. I think that if we had the parallel path for civil and marriage, for marriage and civil marriage and divorce path, that will be actually the ideal thing, because then people could choose if they want to marry and divorce in religious court, or they have the option to go to civil courts. But unfortunately, it's not the case today.
So basically, you're saying that representation is very important, but still actors are constrained very much by the type of institutions they're working on. And even if we have female judges, they're still constrained by the religious courts, which hampers their maneuver and ability to really transform the system. Speaking of constraint, how different is the Israeli Muslim religious courts from other courts in the world, in the Muslim world, and how are there difference in terms of the way they treat polygamous marriages and their treatment of women in general?
This is a very excellent question, because I mean, first we have to remember, as it was written also by scholars such as Musa Aburamadan, that wrote a lot about this issue, that actually Sharia court in Israel, it's kind of anomaly, because it's a Muslim court within a Jewish state. And I mean, before the establishment of the State of Israel, during the British Mandate of Palestine, we had the Muslim Council, that was the body that appointed the Qadis. It was like a very effective a body that was dismantled after the establishment of the state. And on one hand, we have in Israel this system of Sharia court that after the Nakba, the event of 48, that most of the establishment of the Palestinian community were expelled, or we left without a national or religious leadership. And in a sense, these courts are kind of playing this role because they are enjoying a degree of autonomy. So it's an autonomous court. And of course, they are part of the general legal system in Israel, and also the Supreme Court, High Court of Justice can, in matters of jurisdiction, can interfere, although it's limited, limited causes and cases, but still they enjoy autonomy in their decision. So it's an autonomous court, but still it's detached from the Arab and Muslim world. And for instance, if we take polygamy, which is, we have in Israel the highest percentage of polygamy among the Arab and Muslim world. Even if you take what's happening in the occupied territories in the West Bank and Gaza, we're talking about 10% of the 10% in comparison to 20% in Israel. And I'm talking about, in Israel, it's the official statistic, 20% of the Bedouin households are polygamous. But there are also many cases that I saw in my research when I looked at the Sharia court cases of a polygamous marriage with Palestinian women from the occupied territories, and some of them are not registered. So we have also informal statistics. And also concerning like the conditions that allow polygamy, because we know that there are conditions that allowing polygamy according to Islamic law, which mean to treating the women equally. You need to have the also the permission of the first wife. And we see in the Arab and Muslim world that the Sharia court are more strict about these issues, while in Israel there are less. On top of that, the the criminal offense is not enforced. So actually, it's kind of worsening the status of Muslim women in this context.
Is the fact that the Sharia courts in Israel are detached from the other Muslim world, does that hamper their ability to kind of evolve and adapt to the social transformation that society is going through? And are they kind of like stuck in the 50s, or was that the?
Okay, so first, like in terms of like. In Israel, like the substantive law that is applicable in Sharia courts is actually the Ottoman law. And think about this paradox, like in Turkey, this law is no longer applicable, but in Sharia law in Israel and Syria, Lebanon, it still is. So we basically have a kind of frozen kind of law that's still taking place in Sharia law, while in other places it evolved. And I think that is also the entrapment of the Sharia court in Israel. And we see it that since it's the religious court, a religious marriage determined by a religious law, the Israeli legislator didn't know what to do with it. That's why he went to the criminal prohibition. So we see a criminal prohibition on polygamy, we see a criminal prohibition on marriage of minors. And actually, it's a great paradox, because taking the criminal system, I mean, when you need such a heavy burden of proof, and even if you will now take a polygamous suspect and put them all in jail, the fact is that polygamous marriage is still valid. So I think that we need to think about something else. And in this regard, actually, the Sharia Court of Appeals in Israel is very creative in since it's enjoy a wide autonomy. It's also trying to evolve, and of course, it's affecting from other jurisprudence in the Arab and Muslim world, and it's affecting its ruling as well. But still, we're talking about that still religious structure that constrain them eventually.
And so I have another question. Sometimes when we think about kind of the customary law, it's good to understand more about it through the exception to the rule. And I wanted to ask you, in terms of the cases that you did find, the very few ones that were prosecuted, that polygamous marriages were brought before the court, could you tell us under what conditions were those very few cases that you did find?
I mean, it was really rare cases, and actually, after in 2018, there was an important committee in Israel, a Palmore committee, that dealt with this issue of lack of enforcement of polygamy, and actually dealt with several aspects of it, not just the legal aspect, also try to tackle the social aspect and other aspects in order to find a solution for this phenomenon. And since, let's say, the last 3 years or so, we're seeing that the state's starting to prosecute polygamous marriages, and because the policy has changed. So it's interesting, when I looked at the data of, let's say, until 2016, the state was very much cautious. It talked about issues of proving, although if you looked at the Sharia court cases, you see the proof, but it was very, very cautious. But now we see that it's actually prosecute polygamous marriage, and we see a new phenomenon that there is a decline in the cases that brought to Sharia court for ratification of marriage, because they are afraid that they will be prosecuted because of the change of policy. So they just say, we're not a polygamous couple, we're just a common law couple, which is interesting because according to Sharia, there's no such a thing, a common law couple. So it's very interesting, because here, to complicate this, if we talked earlier about the conflict between customary law, Sharia law, and criminal law, here we have something new, that adopting new legal terminologies that are used in the Israeli public among Jews. They are borrow these terminology to evade or maneuver the law and evade actually a criminal prosecution. And I found it very much interesting, the way that the law and different legal system intersect, and the way the parties as well, the Bedouin community also using sophisticated way as well to maneuver the law. So it's very interesting dynamic that we are seeing now in the last few years.
And what prompted this change of policy? Was this activist or was it institutional, or what drove it?
I think it was a combination of, I mean, of course, there was a very, feminist, Palestinian feminist movement in Israel has been active on this matter for the last 20 years or so, but it took time until the state started to listen to these voices. But actually, the interest didn't came out of like a good will helping Bedouin women. It was during the period when Ayelet Shaked was the interior minister, and then actually it was out of demographic consideration, since they started to see that there is a growing percentage of polygamous marriage that taking place with Palestinian women, and then there was this concern from Palestinian back of return from the back door, and then they started to pay attention to it, and afterward this committee was established. But actually, Attorney Amy Palmore was a positive personality that tried to listen and to find a good solution for it. And once the recommendations were published, there started to, pay attention to it.
This was under her leadership as the head of the Ministry of Justice?
Yes. Mm-hmm.
And in a sense, this actually comes back to what you write about it, that in a way, polygamous marriages go counter against the narrative of the demographic threat, which to audience that is not familiar is the idea that if Palestinian minority continues to have more and more children, they will have a larger population than the Jewish population, and that will be a demographic threat. So despite this going counter to this idea of the demographic threat, what do you think actually maintains the idea of not enforcing polygamous marriages? Is this really the attempt to try to not come into conflict with the Bedouin minority, or are there other things?
This is an excellent question, and actually it has to do, I mean, on a first glance you will say, oh, okay, it is perhaps a multicultural attitude toward a minority group. We want to be sensitive to them, to their cultural norms, etc. But it's not. I think it is the motive are more colonial, has to do with control policies of the minority. And actually, from what we see in other contexts, in colonial context, and the tension between the when the state intervene in the private sphere, it kind of intervene when it's good for its interest. And when you want to, we know in the case of the Bedouin society, there is an ongoing conflict related to land issues and the issue of the unrecognized Bedouin villages in the Naqab, which the home demolition, etc. It's ongoing conflicts, it's real conflict. When the state is very much active in demolishing house and enforcing the law. Okay, now it's not multicultural toward the a rural, urban, rural way of Bedouin life. On the contrary, but on polygamy, it's say, okay, we don't want to intervene in this private sphere because then it will be too much, and we might lose our effective control. But I think now it's changing because there is, let's say, national bigger cause from an Israeli like colonial perspective, which is Palestinian women marrying with Israeli with a Palestinian Israeli citizen, and this is something else that it's we will prioritize and we will start to enforce, and we see this change in any case. And actually, it's the same. It's amazing to see, like it's the same when you look at India in the past during the British period, and the way they intervene in all kinds of practices, that the sati or other practices. It's amazing, same thing. But of course, it's not just the dynamic of control. We're talking also about, and that's why I think it's not just legal issue. It's also you have here patriarchal norms that need to be eradicated, and we need to put more effort internally to empower women so they will have the ability also to resist it and exit.
So if I'm getting you right, so what you're saying is that the lack of enforcement was kind of an idea of choose your battles, but once polygamous marriages with Palestinian women were perceived as a national threat to maybe even to national security, or being securitized as an issue that is threatening the Jewish majority, then basically enforcement started to be much more stringent. So as you know, this webinar follows our seminar on sociology of gender and in Israel as a microcosm. And one of the important things that we don't cover as much as we're learning of the different atrocities women face is what kind of strategies do women use in order to resist, and how are they empowered? And if you can share with us strategies that Bedouin women, which are really amazing. I remember going with you to the Negev and seeing the different initiatives. I think that could be a really interesting thing to listen about from our viewers.
Thank you, Tamar. So first of all, I think the most important thing is to see the amazing change that Bedouin society is going through in the last few decades, especially regarding the status of Bedouin women. I mean, the percentage of women in academic institutions, whether universities or colleges, are higher than male students, Bedouin male students, which is an amazing. I mean, it's create other problem, because then these women coming back to their society, and it might create conflict and gaps, but still it's an amazing, and also like breaking glass ceilings. So we have some Bedouin professors, and it's an amazing thing to see. And I think this is part of it, because education will enable this mobility, and it will, I think what we need actually is to expand our imagination, and to provide an example as successful women that it's possible to exit this patriarchal norm. And we cannot, I think also Bedouin feminists realize that we cannot wait until the state will enforce the law or change. I mean, we have to be very much assertive in asking the state to enforce the law, and to provide the opportunity to Bedouin women, so they will have the ability to resist such norms. But I think there is, since Bedouin women are not monolithic category, also the strategies are not monolithic, and we can find all kinds of strategies. I mean, it depends. You can find women that believe in fighting from within. There are women that believe, the writing of Kandiyuti to bargain with the patriarchy. There are women that believe in promoting liberal view, secular view. And I'm so happy to see that we're talking about multiple diverse strategies. Like in the past, we were like just trying to raising awareness to this topic and break the silence around it. And today we have internal debates of, okay, how we want to fight it, whether it's legal, social, or internally, or what is the right rule, and that just demonstrate this enormous, amazing shift that is taking place. And eventually we have to remember that we are the ones that have the power to change. And if the state will see that we are assertive about it, it also will change. But unfortunately, these days are dark days in Israel, with all the legislative initiatives that are taking place, and the actual threat on the democratic sphere in Israel. So even the tools that we have, the legal tool of petitioning to Supreme Court, or I don't know, freedom of expression, it's all under threat. And of course it will affect in a very great deal the minorities in Israel. And I'm very much concerned. I mean, I'm talking about this issue, but the situation is will be worse, I think. But we shouldn't lose hope, and we should continue and raising our voice against these injustices.
Do you find that the new proposal that's on the table to extend the religious court's jurisdictions to civil matters, is that going to further curtail women's rights, Bedouin women's rights?
Yeah, I mean, this initiative was actually passed the first preliminary reading today, and it's talking about rabbinical court. But I wrote with my colleague a position paper analyzing how it will affect legal status of women in Israel in general, not just Muslim or Jewish, etc. And we're very much concerned about this step, because as we know, fundamentalist groups have the tendencies to agree and to be in solidarity with each other. And once this will happen in rabbinical court, of course, it will affect in other religious courts, such as Shari'a court, and it not just will affect it, it will also take us back, also take back the successes that we made, the achievement that we worked so hard to get. For instance, the issue of fight that we had that Muslim and Christian women would be able to go to family court, not just Sharia court, in matters that are not marriage or divorce. It was after a big fight, and then of feminist activists. Nothing is guaranteed, you know. All this achievement under threat, and we shouldn't take anything as granted, because everything is under attack, and will affect women, will affect minorities, will affect us all.
Hello, everyone. Due to technical difficulties, we were unable to see the questions posed by the audience, and therefore I have asked Rawia, who kindly agreed, to make a makeup session for us in order for her to answer some of the audience's question. So thank you so much, Rawia, for joining us. And I would like to start off by asking you a question asked by Maura, which asks, do the Sharia courts refer cases of polygamy to civil authorities?
Okay, so as I mentioned yesterday, since the exclusive jurisdiction matters of marriage and divorce is subjected to religious court, and we have the criminal prohibition on polygamy, the Sharia court is ratifying these marriages, but can submit or warn the parties that it is a criminal offense. And then the ones that are in charge to prosecute these cases is the general prosecutor. But Sharia court doesn't have the authority to submit or to file complaints against these felonies, since it is on the criminal sphere, not in the religious one.
Thank you. Jerome has asked, wasn't there a case of a Muslim Palestinian in Israel suing for polygamous rights under Shari'a? I recall a Supreme Court ruling that while Shari'a allows polygamy, it doesn't not command or mandate polygamy, so no permission given.
Yes, actually, there is a famous case that brought to Supreme Court of Justice in 1954, the Milhem case, which was brought to the Supreme Court 3 years after the enactment of the Women's Equals Right law that actually applied the criminal prohibition on Muslims. And it was a case of Naif Milhem that wanted to marry the second wife, and the Qadi, the Muslim judge, wouldn't perform the ceremony. And then he petitioned Supreme Court, and the Supreme Court rejected his petition, stating that monogamy should prevail in the Israeli context. But that was one of the, as I recall, the only case that brought to a Supreme Court challenging this, and it was, as I mentioned, 3 years after the enactment of the Women's Equals Right in 1951.
Okay, thank you very much. Carol has asked, how do you balance civil versus religious law? For example, in the United States, the courts have let certain issues in the Hasidic community alone. It's not just a private versus public, but also religious versus civil.
Yes, I think the case of Israel is very unique because we're not talking about autonomy for certain groups or like a multicultural attitude, but it is part of the law. The fact that religious law prevail, and the fact that we have religious court that have sole authority and on such matters, it provides them with a wide juridical power to discuss an issue. So it's not an issue of just providing them with autonomy. And that's create actually the many contradictions or paradoxes, because as I mentioned, we have the Women's Equals Right law that enacted in 1951 provided a wide range of protection for women. It is a very progressive legislation on the one hand, but it excluded the marriage and divorce matters that will be under the sole jurisdiction of religious court. So in that case, we have a unique situation differ from other contexts that has a separation between religion and the state.
I see, thank you. Ella has asked, what are the legal consequences of Bedouin women involved in polygamy fleeing from their marriage?
The option for divorce in the past, it wasn't very common, but we are witnessing in the last decade actually increasing in the cases of divorce, Bedouin women starting to initiate divorce. Actually, my current research tackle some of these issues concerning divorce patterns among Bedouin. But these women risk of losing custody on their children, they might also be, they're in risk also for delegitimation by their own society and the community, and they might pay a heavy price. But the exception for these cases, when we find that women has, take such an action, but has some sort of support from, usually it's a male figure, like father or uncle or someone that can assist these women to exit these marriages, but to fight for their rights, such as the right for custody on their children, etc.
Is there, so under the Jewish tradition, there is the idea of Isha Moredet, the rebel woman. Is there an equivalent in Sharia law?
Actually, yes, there is. I mean, there is a concept that's called Bet Ta'a, which means that in case of conflict, you can file a petition to the Sharia court to ask the wife to obey to the man as part of this perception of marital relation. Yes. There is many equivalent between Sharia and Jewish law, actually.
And these equivalents also are applied discriminatorily in both religious courts against women?
Yes, absolutely. I mean, it's the same patriarchal structure, it's the same mindset, even like religious courts. And if we want to talk about equality, so I always tell my students, don't worry, all religious courts discriminatory towards women, they are equally discriminatory towards women.
So another question that that taps into that is, you've talked about how the Sharia court in Israel is kind of frozen in time, and Maura has asked, why can't the Sharia courts evolve in the Israeli context? What's stopping them from changing? And maybe you could elaborate a bit more on what is the role of the state of Israel in preserving the state of affairs.
Yes, I mean, you have to remember, like, the definition of the state of Israel as a Jewish and Jewish democracy, basically. So the Jewish component, actually, that we have the public sphere is dominated by Jewish symbols, and also there is a constant debate about the Jewishness of the state and its effect on the public sphere. And we don't see the same thing happening within the Palestinian sphere. It's a very limited autonomy. And as such, it's not changing because we have a colonial setting, and we have a domination that's preventing these courts to evolve. And we also have this kind of bargain between religious court and patriarchal figures. So also that prevents these courts from evolving. So it's different. It's kind of a anomaly. It's not like in other contexts. Here you have this kind of anomaly of Sharia court in a Jewish state, which affect the way that they are operating and the way that also frozen in their ruling and in other aspects as well.
Could you explain a bit more about how the colonial setting affects or circumscribes their ability to change and to adapt to the more modern times?
Yes, so the case of Israel, as I see it, is a settler colonial case, which means, I mean, like in other contexts in the world, it's different from what we know as the classic colonialism, what we had in British Empire or France or etc. It's the settler colonialism, as Patrick Wolf and Veracini treated it. It's like it's not one event. It is a structure of domination, and in this structure of domination, it's actually you have ongoing control policies toward the minorities, and you have also as part of this, you also actually controlling the way that this group is operating. And in my research, I actually usually, when we're talking about colonialism and colonial logic, we most of the scholarly literature focused on matters of demography or land, because it's much easier to show how it's taking place. But in my research, I actually looked at family law to demonstrate how it is a political paradigm, how lack of interference in the private sphere actually enforce colonial setting and preserve patriarchal values. And that's the thing with this colonial logic, or the way that colonialism is taking place. So when you have patriarchal structure and religious court and colonial setting, it is actually affect negatively and on the ways that these courts can evolve since they are part of this colonial structure.
Speaking of research methodologies, we had a question concerning asking, could you describe the research methodologies you undertook for this research? Has there been any research conducted with these Bedouin women themselves to better understand their experiences, realities, and the legal challenges they face?
Actually, since it was a legal research, I had a combined research methodology. I looked at a Sharia court ruling between the years 2008, 2016. In particular, I looked at cases of ratification of polygamous marriages. And I sampled these cases to look on the practice of Sharia court and the way they are routinely ratify polygamous marriage. This is one methodology. Another methodology that was used was legal history methodology. I conducted the archival work, both at the State Archive and other archives in the state, looking at the history of the legislation in Israel related to women's equal rights and the representation of Muslim women in the process of legislation. I looked on a correspondence between the Muslim leadership during the 50s and the 70s and the state. Also I looked at some documents related to the British mandate to understand the origin of the prohibition against bigamy. And so I used basically combined methodologies that enabled me to analyze polygamy in a more refined way and to understand all the dynamic and the actors and both the legal and the history of the law. It wasn't, and I think it was something missing in my research interviews with women, but this kind of research is conducted actually by other sociologists to understand the experience of Bedouin women and to bring their voices. But for me, I was interested to explore the gap between the criminal prohibition and the non-enforcement of it, the gap between the law on the books versus the law in action. That was my research question that drove me to look at these kind of methodologies.
And to conclude our session, the last question is from David, who's asking, could there be a fear of the Justice Department? If they enforce the law, there would be pressure from the Muslim authorities?
In the past, actually, there were such a consideration, but actually within the committee that was established and was headed by Attorney Amy Palmore, there were official representatives from the Sharia court in Israel, and they were part of this process. So that's why eventually the recommendation of this committee were not far-reaching. Were very conservative eventually, because they wanted to find some solution in the middle that will satisfy Sharia courts as well.
Okay. Thank you so much, Shari'a. We really appreciate you joining us and doing this makeup session and answering everybody's question. Thank you for the fantastic and fascinating talk. And I want—
Thank you, Tamar. It was a great pleasure.
Thank you so much. Bye-bye.
Bye-bye.